But speaking for myself, we belong to that state and we have lived through this 370. We have been brought up in this 370. It's a part of our mindset, this 370. And we were really shocked when the notification of 272 was issued on 5th of August 2019. It was unexpected and one could never imagine that this could so suddenly happen. Because in order to understand this 370, there are few approaches to its understanding. One would be, in the first instance, if the Maharaja way back, perhaps before the birth of all of us, when he entered into instrument taxation only, why didn't he enter also into merger agreement at that point of time? This debate would not have been here. It could have been straightway a part of the Union of India. He did not do that. So that's a question which needs to be inquired into. Why didn't he do that? That's number one. And number two, if he only entered into instrument of accession, what is it that he parted with as a sovereign king? And what is it that he retained with himself? My understanding of the case is this, and perhaps many things will become clearer, that the Union of India by itself was one authority. This Maharaja of a state, of a very large state among the native states, was another authority. When the Indian Independence Act was passed, Government of India Act 35 was applicable. They became all independent sovereign states. All these native states, including the state of Jammu and Kashmir. When we proceed on that premises that they became independent sovereign states, then comes the question of accession to either of the dominions. All other states in India, native states, whether they were as small as 1 kilometer or they were big states, either they merged with themselves, but ultimately all of them merged with Union of India. And this merger word is extremely important, and I think that's the basis of this 370. He did not enter this merger agreement at all. He entered into standstill agreement only with Government of Pakistan. The Government of India did not agree to enter into the standstill agreement. This was the situation in 1900, prior to 1947. Nonetheless, because of the extraordinary situation which arose in the state of Jammu and Kashmir, having no choice in the matter, he enters into this instrument of accession on 26th of October 1947. What does he do under this? He, in simple language, he says that the Union of India will have the power to make law for defense, communication, and foreign affairs. He doesn't give any other power to them. Only these three subjects. But for remaining subjects, I mean, running a country, you need so many laws. For remaining subjects, he retained all the powers with him under clause 8 of this instrument of accession. Now, in the absence of merger agreement, obviously these laws, this power to make the law, and where he had this legislative autonomy, would not have been transferred in the absence of such an agreement. This is the situation. He left. Thereafter, he asked his son to take over. His son takes over Dr. Karan Singh. He also does not enter into any kind of merger agreement or supplementary agreements. This is the situation on the one side. On the other side of the picture is that so far as the Government of India is concerned, it was already in the process of making the constitution. That was not meant for the state of Jammu and Kashmir, but for the entire country. All native states have merged and ultimately become part of the Union of India. All those native states. There were three only left. That was Junagadh, that was Hyderabad, and state of Jammu and Kashmir. So far as Junagadh is concerned, there the king belonged to a certain sect. He wanted to accede to Pakistan, but the people did not want it. So therefore, they ultimately held a referendum in Junagadh on 20th of February 1948, and the people overwhelmingly voted to be a part of India. So far as Hyderabad is concerned, the situation is altogether different. Ultimately, Hyderabad also merged with India. But state of Jammu and Kashmir, out of these three, did not enter any kind of an agreement. It remained a separate state, but with only power with the union on these three subjects which I mentioned. But when this Constitution of India was being made, a significant development takes place at that point of time, which had its impact on this relationship, which was normally between a native state and the Union of India. That is, the situation arose in the state of Jammu and Kashmir such that the matter had to go outside the country to United Nations. When it went to the United Nations, as many as 5 or 6 resolutions were passed there. They also said that this instrument of accession should be put to the people's ratification. This is on, not only they said it there, on 27th of October letter, which has already been read to your lordships, it also said that as and when the situation in Jammu and Kashmir becomes normal, this particular instrument accession will be put to the ratification of the people. It does not take place. The UN security resolutions do not take place. But yet, the Constitution of India was being made, and there was only instrument of accession. These are extremely 3 factors which resulted in making this Article 370. Now,
what are the three factors? What are the 3 factors? We can just itemize them.
No merger agreement?
Just one second.
Yes. 27th October 1947 letter of the Governor General. And 3 UN resolutions. So the third factor was UN resolution. These were the 3 factors. Now this is the situation preceding making of this Article 370. Now when it goes to the Constituent Assembly, at that point of time, the representatives of Jammu and Kashmir were not there in the Constituent Assembly. They become members in June 1949 after amendment is carried out in the procedures of becoming a member of the Constituent Assembly. So we have the representatives from Jammu and Kashmir in June 1949. By that time, almost entire Constitution of India had been adopted. Because finally the Constitution is adopted on 26 November 1949. So hardly few months are left when the representatives of Jammu and Kashmir become members of the Constituent Assembly. Then in October 1949, this article, which was originally 306A, is debated. In that debate, which references can be made, I'm just giving the narrative to the whole case, but I'm standing here for. There, the mention expressly is made that, look here, the position of the Jammu and Kashmir is uncertain. Why is it uncertain? It was uncertain because, number one, of the Governor General's letter of 27 for 1947, and the government of India being entangled, that's the exact word used in the Constitutional Assembly debates, being entangled before United Nations. So one doesn't know what happens, whether this is going to stay, this is not going to stay, whether it should merge with India, it should not merge with India. This is the situation existing. And it is in this background that somebody had to think of, what do we do with this state? It had entered into instrument of accession. It was one of the federating states, if I put it that way. But this was not fully a federating state, like any other state, because of the absence of merger agreement. So some way had to be found. Madhya's observation was correct, that after this instrument of accession is executing and 370A is made. If we look at 370A, it seems to absorb, subsume within itself that power which the king had, the Maharaja had. What is the power which he had retained with himself? He had retained the entire residuary, if I say so, sovereignty with him. What was the concept of sovereignty? The power to make the law. What does it mean, sovereignty? That is the whole thing. The power to make the law. He had retained that with himself. I'll make the law, except on these 3 subjects. Law related to defense, law related to foreign affairs, law related to communications. All other powers I will retain. Then the question further arose, now what happens to Jammu and Kashmir? We need a constitution. How do we run the state? We earlier had a constitution of the Maharaja, that's of 1996. But the structure of the constitution was different. There was Praja, there was the king, he had the exclusive power under section 5 and 6 of that act, he could do anything. But since the democracy had set in, so therefore that particular constitution had become inappropriate. That's why Dr. Karan Singh in his communication says, because of the change of situation, we need a new constitution. Why the need for new constitution? Because the state had retained with itself the entire powers. So here essentially also we are concerned with the right of the state of Jammu and Kashmir. It's not the right of an individual. It is not simply the right of the people of the state. It's the right of the state which is in question. That what kind of right is the state possessed under the instrument of accession.